proceed.
Yes, Your Ladyship and my lords, we have filed together with the record of appeal that runs.
Propaganda, so that I will not interrupt you. 10 minutes.
15, can I have 15? I wasn't in the initial, but it's okay, I'll summarize.
You are good in doing précis and summary, so do not disappoint.
Okay. Yes, I will not disappoint. Yes, Your Ladyship, as earlier on stated, I appear for the Honorable George Onyango Aloo, the appellant, who at the time that the cause of action arose in this matter was the Speaker of Kisumu County Assembly. My lords, we filed an appeal that runs to 454 pages. Together with the record of appeal, my lords, we have filed submissions. We have filed two sets of submissions. Substantive submissions, Your Ladyship, that run to 10 pages, and a summary called further submissions that runs to the initial submission is 13 pages, the second submission is 10 pages. I will summarize the heads of arguments, Your Ladyship, as set out in our submissions.
Senior Counsel, before you proceed,
Yes, my lords.
looking at your prayers,
Yes, sir.
if, assuming we are to allow this appeal, some of your prayers have been overtaken by events, isn't it?
Yes, it is true, my lords.
So which ones are you abandoning?
Your Ladyship, my lords and your Ladyships, the appeal, since the term of the assembly where the appellant served as speaker has expired, we would not seek reinstatement back to the position of speaker. That is expired, overtaken by events. All we are seeking in this appeal are declarations that would declare that his dismissal from his position as speaker was undertaken in violation of the Constitution and the law, was therefore unconstitutional, and that, my lords, I think that is the substantive prayer, and perhaps the court will direct who bears the course of this appeal. Beyond that, my lords and your Ladyship, we would not claim anything else. Of course, the import of that declaration would lead to other claims, including liabilities by the respondents on questions on benefits and other things. I think that is, yes. I could just proceed, Your Ladyship, just so that I save time. Together with the submissions, we've also filed a list of authorities and a case digest that runs to 74 pages. I will be referring to specific cases. This is an appeal that is hinged on 3 grounds. The first ground, Your Ladyship, and this is just on point, that one, the appellant, Mr. Honorable George Onyango Aloo, was removed from office unfairly and in contravention of the rules of natural justice. I will be pointing to the judgment of the Honorable Matthews N. Duma, which appears from pages 432 to 449, and specifically, my lords, to paragraphs 41 to 45, which is the penultimate paragraph, where the court found, my lord, that once there's a criminal matter that is pending before a party, then of necessity, on the principles laid by Justice Mumbi Ngugi in Nairobi ACC Criminal Division number 25 of 29 on public policy, a person should be discharged from office merely because they are facing a corruption or a criminal charge. I think for me that is the most crucial. If I convince the court that that cannot stand as good law, and as the court held, where there are clear statutory or constitutional provisions guiding how persons facing disciplinary measures or facing the kind of charges or proceedings from court should be treated pending the determination of the matter, my lords, those procedures should be followed. We will show the court, my lords, that the court misdirected itself when it found that the procedures that obtained and that led to the removal of George Onyango Aloo as Speaker, my lords, and your leaderships, were not followed or were followed. We will demonstrate to the court that, number one, there was never a fair hearing of the appellant at all. Indeed, he was hounded out of office of Speaker without following due process. Article 47, my lords, and your leaderships, provides that every person has a right to administrative action that is expeditious, efficient, lawful, and procedurally fair. We have highlighted this, and we have highlighted the case of Chepkemei Mukenyang and Evanson Kemei Lomadum, which is authority number 1 in our list of authorities to support this position, my lords. The Honorable George Onyango, the appellant, and page 188 and 189 of the record will show, was informed of the charges before him and was only given 1 hour to appear before the assembly. The communication was through a mode of email that we have displayed at page 44 of the record of appeal. My lord, the email was sent on the 18th of September 2019 at 1:26 p.m. and he was required to appear within the hour. The said impeachment, my lords and your lordships, was scheduled at exactly... Yes, my lord.
Prof, so that you don't squander your time, let me just caution you that you now have 5 minutes.
I will move quickly. Your lordship and my lords, he was never heard. Within the time that he attempted to access the premises of the County Assembly of Kisumu, he was blocked by goons and never attended a hearing. The court, in its misdirection at paragraph 44 and 45 of the judgment, my lords, should have considered the incidence of lack of a hearing at all and a violation of Article 47. The court therefore should have held that his dismissal or removal as Speaker was unfair and in violation of the Constitution. My lord, that is a sufficient ground for this court to allow this appeal. We refer the court to pages 446 and 447 of the record to demonstrate how the impeachment was undertaken in violation of the Constitution and of the standing order. My lords and your lordships, the second ground that we will focus on is that the breach in itself violated Standing Orders 61, 1, 2, 3, 4, and 5 of the County Assembly Standing Orders. My lord, those orders require that a substantive Speaker that is duly elected presides over the impeachment. What the Assembly did, and we have demonstrated this from the record, my lords, the Assembly purported to install a stranger to undertake the process of impeachment. We have displayed the standing orders, my lord, at pages 286 of the record to show, my lord, that at the time the Assembly designated the third respondent, the first interested party, Honorable Elisha Jack Oraro, who was then an MCA, to sit as an acting Speaker and did not allow the then Deputy Speaker who was in the seat, the Honorable Roy Samu, to sit and to proceed. We have displayed at page 188 the requirement of the law on how proceedings should be undertaken, and an express violation, my lord, by the leader of majority then, the Honorable Ken Onyango, who proceeded in violation of the law to designate a third party, Jack Oraro, to sit and preside over the proceedings. My lord, this and procedural violation of the standing orders. ought to have been considered by the judge, the trial judge, and would have led him to find, my lord, that the procedure that was adopted in impeaching the Honorable George Onyango Aloo was in violation of the standing order and orders, and therefore the processes that guided the removal of a speaker from office. We have, my lord.
Please go to your back point, bro. Go to your back point.
My lord, lastly, my lord, the judge seemed to have removed or considered the only single issue of public policy, and relying on the decision of Mumbi Ngogi, found that when an individual is facing corruption charges, presumed innocent as he may be under Article 52 of the Constitution, my lord, that individual should be impeached from office on public reasons. My lord, the judge observed that the charges at paragraph 44, the charges the respondent was facing was in respect of his employment at Lake Basin Development Authority. But he nevertheless proceeded to make a finding that that was related to his employment at the county assembly and as a speaker, my lord, in spite, my lord, of the fact that the courts have held that presumption of innocence as a cardinal constitutional principle must be observed. Every individual facing a charge is never found guilty. It is never guilty until presumed otherwise. They are innocent until the process is exhausted. We have relied on Mumu Matemo and Trans Society of Human Rights on this principle that public policy would only be a policy to be considered at the end of a process. Interim measures that that lead to the inculpation or the making, my lord, presumption of guilt violate the provisions of Article 52 of the Constitution. My lord, that again is a ground and misdirection that the court, though having considered, my lord, should have relied, my lord, on the provisions of the Constitution. My lord, we pray that you allow the appeal and set aside the judgment of the Honorable Justice Matthews Manderi, delivered on the 11th of December 2019. We'll also pray for cause, my lord. That's all.